Hey there, welcome back to yet another video on this channel. This video or this session is going to be a bit unique or novel for me because I usually don't discuss question papers from marks point of view or for releasing answer keys as such. I generally prefer to discuss question papers from concept point of view to see if there are any new use cases have been proposed for which we can go through the act and identify a solution for the problem that has been proposed. Because this is nothing but a test run for the real life journey that you're going to take up once you become a patent agent. But then many of you have requested to discuss the paper 1 this time. So here we are. Let's start discussing the paper. So we are going to discuss the questions from set A, just so that you know the order of the questions. So let's go through the questions. So here is the first question. Mr. Shatrughan is an associate professor in some college. He has filed 2 applications, one on 19th Feb, second on 20th March. Later that year, he came to know that request for examination must be filed. Now, what would be the prescribed timeline? Perfect. Now, why are they asking this question? Because 14th March 24 is the date. Any application filed before this date still has 48 months as the timeline. However, anything that was filed after this has 31 months as the deadline. So for A, we still have 4 years, 48 months. So 24 plus 4 is 28. So we need to have 28. But for these guys, we cannot have 4 years. We would have 2.5 years, 24 months plus 7 months. So 26 plus 7 is 10. So D is the answer for this. I hope this is clear. This was the date, this was the concept that they were checking for you. Let's move to the next question. So here is the second question. Innovate Pharmaceutical patented a drug which is immensely important for public health. Okay. Medway is another corporation. After 3 years of the grant was successful in getting compulsory license. Perfect. So we have a patentee. CL has been granted after 3 years. Perfect. Another company, Pharma Wonders, is also into drug manufacturing business. Same product. Question is still not been worked in India. So they identify that it's still not been worked in India and the reasonable requirement of the public has not been met. So after CL also the conditions are not justified or met. So what happens around that time? Somebody else can come and ask for CL, can only apply for CL, but may not request for revocation. No, this is not right. Why are they saying can only apply? You cannot limit somebody's options, right? Second says can file a request for revocation for patent only after the expiration of 2 years. So 2 years is perfect from the date of grant of the first compulsory license. So this looks nice. Only central government is eligible. Now, whenever they say only, I don't like it. So this is not nice. Both Pharma Wonders and central government, yes, may file a request for revocation of the patent, but only after 3 years. Nah, only after 3 years. Again, the timeline is not nice. So if you look at section 85, you will get to know about the timeline and as well as who can do it. So what is the answer for us here? The answer is only 2, which is C. Perfect. Let's move to the next question. So there is one guy who is an ex-employee of Hydra Power Technology and was involved in development of hydrogen technology. Very good. He recently came to know about granted patent obtained by HPT. Okay. In which he made a substantial contribution towards a claim subject matter during the, see it says claim subject matter, substantial contribution. However, his name was not included. Okay. Inventor was not included in it. Is willing to explore the possibilities in the Patents Act to include his name as inventor in the said granted patent. He does not expect any support from HPT as their relationship is no longer friendly. Never burn your bridges. In this context, which of the following is possible? See, so this is post grant. One we need to worry is post grant. So section 28 is not applicable. Okay, can apply form 8, this is section 28, not applicable. Can make a request on form 8, not applicable. Must seek an approval consent from, but then what section? They have not provided anything. Dr. Chinappa Swamithan's name in the patent register and complete specification cannot be included now. Okay, so what options? See, I can usually take post grant opposition route 25, then based on that wrongful obtainment 26 can help me, or 52 if I go for revocation as such, right? But then they have not given any options as such, so I don't know. I'm inclined to hit D with this. So wrongful obtainment can help us to get the patent on our name for the portion of the claims that were contributed by us. Section 26 also helps us with that, and section 52 also helps us with that. But then given the choices, I think D is suffice. Let's move on to the next one. Which of the following grounds may not be used for availing grace period provisions under section 31? So grace period is only for section 31, and it says may not be availed. Section 31 is about the exhibition, right? So consent of to an inventor as for display of the invention, correct? This is a valid ground. The publication of any description of invention happened in the consequence of the display or the use of the invention at any such exhibition. This is also provided this exhibition is the same exhibition that we are talking about here. This also should work for us. Now here it says the description of the invention in a paper read by the true and first inventor before a learned society. This is also fine. So it says may not be used for availing, but all of them can be used. So I think none of the above is the correct answer for this. Let's move to the next question. Your client comes to you and expresses his willingness to file an international application according to the laid down procedure for international phase of application. Your client comes to you, okay. Your client, an Indian applicant, okay. So he would be filing with the Indian Patent Office as the receiving office. Now Indian government has identified a few ISAs, perfect, which is not a competent international searching authority, ISA, international searching authority under the act of the Indian applicant. Australian is also there, Japanese is also there, Austrian is also there, Swedish is also there. All of them are there. All of them are part of competent authorities. In fact, here is the list: AT, Austria, Australia, JP, EP, US, CN. Am I forgetting anything else? Yeah, Sweden also, no? So SE also is there. So I think there is no correct option here. I don't know. Let's move to the next one. Known substance, section 3D basically. Section 3D, known substance, new form of a known substance, okay. New property or new use of a known substance, second paragraph. Known process, machine or apparatus. New property, new use, known substance for known process, machinery or apparatus. Enhancement and efficacy, this is very important part for patentability. Represents the complement of C, mathematics. Thus the set of patentable and non-patentable invention under section 3D of the patent. Oh my god. Actually, what are they trying to test here? It's look like examiner is trying to show off his statistic skill set. Why do you want to test somebody's union or complement of C? Why would they do this? As in, what are they trying to check here? What are they going to check here? I'm not even answering this question. Forget it. Under the Design Act, who is eligible for a petition for cancellation of registered design? It has to be any person interested. This is important. Let's see if there is answer 1B. There is only 1B correct. Should I even try something else? But let's discuss. Application for rectification of a registered design. Whose design it is basically. So anybody who is aggrieved would be this. So I think 2D is matching. Information regarding the existence of registration. Anybody can do it. Anybody can do it. Inspection. Anybody can do it. Perfect. Now in the journal publication of IPO, a company in Seoul corporation found that a design is registered which is prejudiced to their business corporation. The company therefore approached you for help in order to file a petition for cancellation of the registered design. In this context, which of the following statement ground is applicable for such a petition? Your client should be person interested for sure. Design has been published in some publication, USA, oh, everywhere. Basically section 4, whatever things are there we can use here. So either published in India or anywhere else in tangible form is okay, and it actually says prior to the date of registration, so this is fine. Design is not new or original is also fine. Design contains a property mark. They have not mentioned it, but we know that what can be considered as design and what is not considered design. So any trademark included in the design may not be considered as a valid design as such. I'm not sure about it, but then let's see, because for me 1, 2, 3 are correct. Only 2 and 3, only 1 and 3, only 3 and 4. So logically, all of the above. Okay, so Mr. Sunil designed a beautiful piece of jewelry and registered a design for the same on 1/1/23. Few months later, Mr. Kamal came up with a substantially similar design and is willing to apply on a different article of same class. Different article of same class. Okay. See a huge market, of course, desperate to obtain. In this context, which of the following is possible under the Design Act? We know this section 5 and section 6 talks about you can still have design registration even if somebody has obtained it, provided you become the proprietor of the earlier registered design. Mr. Kumar will have to become a registered proprietor of the design previously registered. So B is the answer. Okay. Professor Ranganathan found that one of his students had patented his research work without including his name. Not good. You as his patent agent successfully proved during a post-grant opposition proceeding that the invention was claimed in any of the claim. Similar claim as the previous question, right? This is post-grant opposition. Section C, section 25(2). Hence, the controller ordered for revocation of the granted patent. Now, in order to amend the patent in the name of Professor Ranganathan, you are required to file what forms and what months. This is section 44, not applicable. This is what section is. Form 12 and 3 months. This is, we know, compulsory license. And this is restoration, 63. So the answer is B. A patent having priority date of 1/6/23 was filed in the patent office on 1/1/24. Okay, good. The controller had marked the application for secrecy. 35 sought central government permission. Communication was sent to the central government. We know that central government will review it and declare whether it is applicable or not. So they have found non-prejudicial. Consequently, the secrecy direction was removed. Now it needs to get published. So what is the timeline that we need to worry about? So 1/6/23 filed on, priority date is 1/6/23. So this is important. Filed on 1/1/24 and secrecy direction was removed on 6/6/24. So application should be published within, after 18 months or as soon as the secrecy provision is revoked after 18 months. So in this case, the 18 months have happened or what? No, 18 months would happen in December 24, 12/24, right? So normally within 3 months, no, 12 months are not, 18 months are not over here. Normally within 1 month, nope. 18 months are not over. Normally within 1 month from 1/12/12/24. Yes, this is correct. This is a bit delayed. This is the earliest. So C is the answer. I hope this is clear for you guys. Okay, a foreign-based MNC, Enervate Corp, filed a patent application on renewable energy systems. During examination, the controller had doubt that such a device is against the well-established law of nature and hence may not be industrial applicable. Wow. In order to clear the doubt, the claimed device is not a perpetual motion machine, of course. The controller asked the applicant to supplement the complete specification with a working model illustrating the alleged invention. In this context, what would be the permissible under Act? A complete specification, always a written document, and controller may not ask. Nope, wrong. Controller may ask for a model. Yes. but shall not be deemed to be part of. Yeah, this is perfect. You know what rule is this? What rule is this? Rule 13. Controller can ask for model sample only from the domestic applicants. Nope, nothing like it. None of the above is true, nothing. So I think we got our answer is 12B. Let's go to the next one. Which of the following is true in respect of registration design of particular article under the design act? A design may be registered in respect of any of all articles comprised in a particular class. Yes, we can do that, different applications, right? Controller is the appropriate authority to decide. Yeah, controller can decide. A design application shall be invalidated on the ground of device not being new, as the same design was previously registered in respect of another article belonging to a different class of article. No, this is categorically mentioned in section 6. Section 6. There are 31 classes and a miscellaneous class in the classification system for design. 4. So my 1 and 2 are perfect. 3 is not wrong. 3 is not true. So all of the true is wrong. Only 1, 2, 3 is wrong option. None is wrong option. My option is so 4. I am not too sure 30, 31, but because D is there, let's go with this. Sorry for this guess, but then I'm not really sure whether it is 31, 32 or what, but then D. 14. Under the Patents Act 1970, the provisions of revocation of granted patent in public interest, section 66, is an important aspect of balance the monopolistic rights and public interest. Of course, when the central government is of, or state government is of the opinion that a patent or the mode in which is exercised, it may make a declaration to that effect in the official gazette. Thereupon the patent shall be deemed to be revoked without hearing. No, this is too strong a sentence. Where the central government of opinion that a patent was wrongly granted overlooking the provision of section 3, no, nothing happens. Where the high court never comes in a picture. Where central government is of the opinion that a patent or the mode in which is exercised is mischievous, and thereupon deemed to be revoked. Opportunity to be heard. See, opportunity to be heard here was not given. Here it is given. Section D. Option D, 66. Okay. Always hearing opportunity is given. Let's move to the next one. A patent was granted to an invention titled storage facility on 1905. Perfect. After 1 year, the central government is satisfied that the granted patent is disguised in its title and its reality it is for atomic energy. Wow. No patent can be granted. Section 65. 66 and 65 are in order. In this regard, which of the following is correct? Central government may direct the controller to revoke the patent. Yes. On direction of the central government, the controller, after giving notice to the patentee and every other person whose name has been heard, and after giving them opportunity to be heard, yes, this is all perfect. The controller may allow the patentee to amend the complete specification in such a manner as may be considered necessary instead of, so controller can avoid revoking it if the applicant can amend the application to avoid anything related to atomic energy. So 3 is also correct. So our option all 1, 2, 3, 15, C is the answer. Let's move to the next one. Patent application fails to disclose or wrongly mentions the source or geographical origin of biological material used for the invention. Which of the following action is not possible? A pre-grant opposition may be filed. Yeah, this can be a ground for pre-grant opposition 25.1. It can be used as ground for, yes, 25.2 is also fine. A petition for revocation 65 also is there. So all these 3 are not possible. They are possible. Okay. A controller can suo moto revoke such patents if already granted. No. Controller cannot do anything of like this. So only 4 is the answer. A is the answer for this. A patent was granted on 10/6/22 to Canson Limited. 3/8/22 they issued a cease and desist notice to the competitor Alma Private. Okay. 10/6/22, 3/8/22. So pre-grant opposition is gone, I think, or it's there. 10/6/22. Oh no, it's there. 22/22. Whatever. They're infringing. So which following statement is correct? Alma Private Limited has sufficient time to file a post-grant opposition on the grounds of the cease and desist notice. On the grounds of the cease and desist notice? What is this on the ground? Private limited has sufficient time is there because we are within 12 months, right? Under section 25(2) post grant on the grounds listed in clause A to K and no other grounds. Of course, if they are going for section 25(2), then they have to choose one of these grounds which are there. Post grant opposition under section 25(1). No, post grant opposition is not under 25(1). 25(2) is there. So we are good with B. Okay. Let's move to the next question. In infringement suit, your client managed to convince the court that part of the claim of the patent is wrongfully obtained. Again, 26 and 52, right? What could be the possible consequence of the above situation under the Provision Act? The patent shall be revoked in totality. Why in totality? Because it says part of the claim. So totality is not right. The patent shall be amended excluding the claims in contest. Yes. So the claims which were wrongfully obtained can be removed and the patent can be kept that way. The entire patent right may be shifted or granted to your client in a petition. The entire patent right, no, because it's the part of the claim. So part of the claim can be given to you. A patent may be granted to your client for the claims wrongfully obtained. Yep. So this is correct. And which one is correct? 2 is correct. So only 2 and 4. Perfect. Let's move to the next one. An Indian resident, Dr. Pandit, filed the patent application with the European Patent Office. Indian resident. Wow. Filed directly with EPO. So there is no FFL obtained. January 1. The applicant entered into India through convention route. December 23. The timeline is good, but where is FFL? After receiving the first examination report, the applicant received an objection to written permission under, where to the written permission? Where is written permission? Prior permission, blah, blah, blah. All that is there. Which of the following statement is correct? Post facto permission can be obtained. There is nothing like this. Permission under section 39 by filing form 25 is required only for PCT applications. No, any application that you need to file outside India without filing in India, FFL is required. His application for a patent under this act shall be deemed to be abandoned under section 40. This looks good. There is no need to obtain permission under section when the application has entered India through convention route. No. If this is for foreigners, not for Indian resident. So C is correct. C is correct. Okay. C is the answer for this. Miss Shivagami Devi has qualified the patent agent exam and wants to get her name registered in the patent agent register. She will file her details by filing some form. Later, after 4 years, due to not filing for fee, her name was removed, of course. So she rectified the mistake and want her name to be restored in the register. She needs to apply for the same on form 22 and 23 are the forms that we need to use. Sundaram makes an application for registration of a design under certain class. Okay. So one application per class. Some negligence on the part of the applicant. The application got abandoned. Okay. However, he decides to make a fresh application again for the same design. In this context, which of the following is true? The first application shall become a prior art for the fresh application. See, a proprietor can file same design on other articles in other classes also. So it doesn't become a prior art as per section 5 and 6. That's for sure. Once abandoned, it was not possible to make a fresh application for the same design. No, you can for other article, right? This is too broad a statement. It is possible to make a fresh application on the same design if the earlier application is abandoned and the earlier one may not be prior art. Okay, this is little tricky. It is not possible to make the fresh application in the same class. No, this is not good because you can always file an application for another article, right? So if we look at the option, which of the following are true? So fourth is not true for sure. 1 is not true for sure. All of the above is gone out of the window. Only 3 and 4. 4 is not true. And 1 is not true. I'm sorry, I am taking this option, but because see, it's not considered prior art if you are the same proprietor. You can file in the same class another article, you can file on another class another articles. So option 3 we are selecting here. Let's go to next question. Which of the following grounds of revocation is not a ground for post-grant opposition? Is not an invention is of course a ground. That the invention so far claimed in the claim of completion is obvious. Yeah, this is also a ground. Not a ground, it says. This is a ground. This is a ground. This is a ground that the applicant control any direction of secrecy passed under section 35. This is only for pre-grant and post-grant. This is not there in post-revocation. None of the above. I think 22C. None of the above is wrong option. 22 is C. As per the definition provided in the Patents Act, capable of industrial application. What is the 2AC is the definition. Should be able to made or used in the industry. Manufactured, used, made, utilized, product. So made and used are the terms. Interesting question. Let's move to the next question. A demand for international preliminary examination may be filed at any time prior to the expiration of 3 months from the date of transmittal of ISR and WO, 22 months from the priority date, whichever time limits expires later, earlier, later, 3 months, 22 months, 3 months for sure. So 24 is the answer. According to the prevailing major classification system observed in patent publication globally, which match the system of classification to the example. Oh my god, this is unique. US classification is definitely this one. IPC and CPC, they are almost the same. There is one issue. IPC doesn't have Y as a classification. So CPC can take this, IPC can take this. Now this FIF term is Japanese classification. This is a bigger one, 3-4 terms, so bigger one. Let's match it. One IPC is G06, which is C. 1C, 1C, 1C. Okay, many 1Cs are there. And CPC is B. 1C, 2B. 1C, 2B. Okay, 1C, 2B is US classification is A. Done. Sorry, this is more from experience. There is no concept here. It's just that I have seen this so many times that I know how they look. Okay, let's move to the next one. Xeronius Corporation is willing to start working on 6G technology. Good time. It came to know that Yashobhav has filed a patent application on similar technology. However, the patent office is yet to examine the application as no RFE is filed. In order to decide whether to enter into working in particular technology, Xeronius Corporation decides to file a request for examination. Yes, they can do. A person interested can file request for examination for another application as well. In this context, which of the following is true? Is not eligible is wrong. Can file, yes. However, the examination report will be sent to the applicant. Perfect. No, none of the above. So B is the answer. We have interesting illustration in one of our presentations. Let's move to the next question. Dr. Ramaswamy has obtained an exclusive license for a patent from original patentee, Miss Priya. After a few months, Dr. Ramaswamy notices that a third party is infringing to a patent right. Okay, so this is a license, exclusive licensee. Exclusive licensee have the like privileges of a patentee. Perfect. He decides to take legal action. He can, of course. Based on the provisions of the Patents Act, which of the following is true about legal rights? Can sue the infringer and thus has the same right as the Priya to take legal actions. Yes, this is correct. The court will ignore any potential losses. No. Court will take into account losses of Dr. Ramaswamy. So this is not true. Mrs. Priya may be added as defendant on the lawsuit unless she is already part of the plaintiff. Yeah, if she is not joining Ramaswamy, she will be called as defendant, but she will not be liable for any cost. Yes, legal cost is not there. So 3 is also there, 4 is also there. So what option do we have? 1, 3, 4. 1, 3, 4. So correct answer for 27. Let's move to the next one. An invention relates to ophthalmic solution container with laminate structure consisting of an inner layer of a cyclic olefin interpolymer with a thickness of 500 micrometer and outer layer of, okay, so there is an inner layer of some material 500 micrometer and there is an outer layer with thickness this, and there is a disclosure D1 discloses a bottle with an inner layer of same layer, or 500 micrometer is also there, and polyethylene layer is also there. The total thickness of the bottle is 2000 micrometer, which is 1500 plus 500, looks like 2000. Which of the following is more accurate regarding the novelty of the claimed invention? It's not novel because D1 actually discloses all the inner and outer layer and overall thickness also. I don't know. The invention is novel over D1 because D1 does not disclose the exact thickness. No. Unless we know the claims, how do we know it? The invention is novel over D1 because D1 does not disclose the total laminate thickness. No. I think A is fine because the inner layer and the outer layer, the material that is being used is also disclosed. So 28A. Okay. Bhuvan has invented a cradle made of titanium. This is important. Titanium, which has a swing and 5 or more supporting structures. Sure. Fifth support is strategically positioned to provide better stability. So this is advancement. The cradle has provisions for hanging toys and it can be folded up. So foldable titanium, something like that. A cradle comprising a plurality of supporting structure and provisions for hanging toys. This is too broad a claim because they have not mentioned what material the cradle is used for. They have written a plurality of supporting structure. Remember plurality, they have not mentioned how many because they say 5 or more. So they could have been a bit specific here. They had a foldable structure also, which they have not mentioned here. Any which way. So D1 describes a foldable wooden cradle with 4 supporting structures. 4 hanging hooks for toys is there. A non-foldable titanium cradle. This is foldable titanium. This is non-foldable. So we are unique from here for sure. Here also 4 supporting beams. A non-foldable aluminum cradle with 4 supporting beams having plurality of hanging hooks. So none of them, one wooden is foldable, but none of the titanium is foldable or aluminum is foldable. So Bhuvan has amended the claim and has drafted the following 3 versions of the claim. I'm just moving up. A titanium cradle comprising a plurality of supporting structure and provisions for hanging toys. So titanium is specifically mentioned here. A plurality of supporting structures and provisions for hanging toys. Okay. A foldable titanium cradle, at least 5 supporting. I like this one. A foldable titanium cradle comprising a plurality of supporting structure and a provision of. So these are broad ones. Let's say what they're asking. Which of the above versions of amended claims would be new over the above mentioned documents? So new meaning they have to be, you have to look these claims individually with respect to each one of them. Don't combine them. So this is wooden, this is titanium. So we are good. This is non-foldable. This is cradle, a plurality of supporting structure and provision for hanging. They have not written provision of hanging here. Then we compare with aluminum. So all of them are foldable. So when you see these claims with respect to D1, D2, D3, there is at least one item which is missing in D1, D2, D3. So it is all the above versions of the claims are actually new in terms of novelty with respect to D1, D2, D3. Next one, which of the above versions would be non-obvious over the above version? Non-obvious. See now obviousness wise, if they are saying 4 supporting structure and I am saying a plurality of supporting structure, there could be a scene there, right? That it could be considered as when you combine all of them, some of them are talking about plurality of hanging hooks, they are talking about 4 supporting frames, and they are talking about foldable wooden cradle. So there is some or other elements which are being provided in D1, D2, D3. So we have to be really specific. How do we be specific? Here we have mentioned a foldable titanium cradle, comprising at least 5 supporting. None of them have 5 as such. 4. We have said 5, right? So claim 2 is kind of a good claim that way, because we have categorically mentioned we have 5 and we are foldable titanium. So that way, see, third could be a good one, but then we say plurality of supporting structure, which is there in most of them. Plurality, anything more than 1 is plurality, right? Sorry if I'm being too fast. There are too many questions. Let's move forward. Part B, assertions and reasonings. These are little typical questions. Moving to 31. In India, for filing a divisional application, existence of plurality of inventions is not a sine qua non. Basically, is it mandatory or not? So divisional application, of course, you need to have plurality of inventions to be there in your inventions for you to divide the application. So this is false because it says not, and this one is nothing but a legal way of saying is it mandatory or not. So in our case, this is actually mandatory. So this is false for sure. A patent applicant may suo moto file a divisional application in respect of an invention disclosed in the provisional or complete specification. This is the new amendment that happened, right? So this is for sure true. So we will put D as the option here. In India, a sequence of listing must be submitted as part of the patent application when the invention involves a nucleoside or amino acid sequence. Yes, this is true. The requirement for sequence listing is intended to ensure that the patent office can properly assess the novelty and inventiveness of the bio. Yeah, this is also true. And the reasoning is also correct. So for 32, it would be A. 33, a stamp or label can be considered an article for the purpose of registration of the design. No. Design has to be on article. Article must have its existence independent of design applied to it. Yes, it has to have its functionality. It has to be used somewhere. So 33 we have false and true. That will be, it says when A is false, R is true. So we will put D here. D. The TRIPS agreement is often seen as both a protector of intellectual property and a tool for equitable access. Yeah, they are trying to harmonize the rule everywhere. True. The design of TRIPS agreement, while promoting a global standard of protection, yep, everyone, also provides countries with the flexibility to prioritize essential goods, public health, and economic development based on the local needs. They allow the participating nations to have their own versions of the law or a bit of flexibility there. So this is true. The answer for this would be A, because that's the reasoning for it also. Moving to the next one. The publication of a patent application is an important step in the patent administration system. Yes, beyond this only opposition happens. The publication of patent application provides the public with information about the invention before the grant of a patent with the option for opposition of that. Perfect, true. So let's put again A as the answer here. 35A. Moving to next section. True, false, false, true, 1, true. Okay. Question 36, statement 1. No suit or other proceedings shall be commenced in respect of an infringement committed before the date of the grant of application for a patent. How do I read it? No suit can be commenced before the date of the grant. That's fine. But no suit or other proceedings shall be commenced in respect of an infringement committed before. I don't know how to read this question. There are two ways to read this. Has the infringement happened before the date of the grant and I don't have rights for it? That's wrong, because after publication, I get the rights as if my patent was granted. But the actual suit can only be instituted once my patent is granted. I am not able to read this question properly. Before the date of the grant, is it for no suit or is it for infringement committed? Okay. It shall not be competent for any person in a suit or other such proceedings to take any objection to a patent on the ground that a patent has been granted for more than one invention. This is true. None of your business. This is the controller's job. Controller has to identify this. This one is a little tricky. Can I institute a suit before my patent is granted? Of course, no. But can I claim damages for the infringement that this guy was doing? What if he stops doing as soon as my patent is granted? Then I cannot do anything, right? Okay, so let's put T here. But this is confusing, huh? I am just taking my chance. So when in this case, this becomes C, both are true. I'm taking my chance with the first one. Huh? 37. Only the registered proprietor of a design may obtain a certified copy of any registered design. Only a registered design. Well, anybody can ask for it, right? I want to see what kind of design do you have. In one particular design application, a design can be registered for more than one class. False. Both of them are false. So when both of them are false, this is D. In India, the duration of grace period in Design Act is same as the Patent Act. No, there is no grace period as such. I don't know. False. In registered design, the registered proprietor of the design has the copyright of the design for 10 years, which is extendable for further period of perfect. F and T. Where is F and T? B. 38 is B. Now 39. As per definition provided in the Patents Act, a patented article includes the article which utilizes patented ingredients. Typical way of saying this. Include the art which includes patented ingredients. Patented article means the entire article is patented. No, what patented ingredients as such? A little odd here. False. As per the definition provided in Patent Act, a patentee includes non-exclusive licensee. Non-exclusive licensee? No, patentee is patentee. Others have rights for it. Non-exclusive licensee? No. This is also false. So 39 will be D again. A patent of addition application can be filed on another patent of addition application. No. Only on the main application. You cannot have patent of addition on patent of addition. A patent of addition can only be granted after the main invention is granted. This is true. This is false. This is 2. F and T, 40, F and T, F and T, F and T, B. This has to be B. At times it gets confusing what statement to take, right? Okay, here we are. The major questions. With reference to various schemes, programs related to intellectual property, match the following. You know what? All of this we had in our community tab, if you remember. So Kapila is directly higher education. We know 5B. Do we have 5B, 5B, 5B? Okay, so one of these options is correct. IP Sarthi is nothing but that bot. 4E. Do we get 4E here? 4E here, 5B here. So I think we already have our answer. But let's do the others also. TISC is from WIPO. So that actually 3A justifies our answer here. SIPM, of course, is the body for IP promotion. So we have our answer here. This is SIPM. This is NIPM. And this is IP Sarthi. This is Kapila, we have already right. And this is TISC. 3 is TISC. Please read about it. There is no concept to discuss as such. Okay, interesting one. So the Patent Act, while extending certain rights to the patentee, also includes certain exceptions and limitations to balance the exclusive rights. In the context, match the subject exclusion limitations. So 47, 48, 49. 48 is the right, 47 is the exclusion, 49 is the exclusion. The vessels, the foreign vessels. 47 is government usage, experimental usage, right? So here it says experimental use and scientific research. So this should go to 47 for sure. 2D. So can we write 2? Do we have 2D here? 2D, 2D. Okay, two options, A and B, one of them. Section 49 is foreign vessels. Foreign vessels. So 3. 3E. Okay, we already got 2D and 3E are perfect. So we have to still go. Act for making a patented product for obtaining regulatory approval. This is about Bolar provision. 1C, I think, Bolar provision. And use of, this one, exhaustion of patent rights. This is also exhaustion principle. This is also there in the Bolar provision 107. So I would write 4 here and 1 here. And exceptions and limitations related to farmers or breeders' use of patented inventions. No, this is a different act. So this is not here. 5A. Okay, 1C. 1CI. This is 1 or 2? Act of making a patented product approval for? Yeah, 1. 1 and 4. 2D. Yeah, so A is the answer for this. Should I discuss or You know it, right? It's a standard ones. Let's go to the next one. Match the following case laws and related subject matter that was highlighted in them. Oh boy, this is typical. You know it, you don't know it, you cannot do anything about it. It's hard luck. So let's see what all can we make out of it. I see Ericsson written here, and Ericsson is always about standard essential patents. Okay, so we got our first match here, 4B. In the answers, we have A, B, and D as relevant answers. My God. I know one more, which is Whirlpool of India versus Videocon. This was about design infringement. So we are still left with A and D. I'm sorry doing this deduction method, but another I know Saurav Chaudhary versus Union of India. Deadline was missed or something happened because of agent's misconduct. So this one is matched to A. Do we get lucky? We got lucky. I'm sorry, I couldn't add much value to it. So one is to C, copyright and design overlap exclusive. So microfibers versus breather is okay. It would be good idea to read it. 3 is with D, Syngenta, divisional application content. Oh my God, this is interesting. I knew this. This is where it was realized that on your own also you can file a divisional application under section 16. Okay, I would not want to give marks for this question, but then okay, answer is A. Under the provision of the Patents Act and rules, failure to comply certain requirements may lead to possible consequences with the patent application. Granted patents in the context match the following: revoked, withdrawn, abandoned, have been abandoned, revoked. Do you recall something? This is coming from our community post where each one of you was asked to define it. Let's go through it. Complete specification not followed within 12 months of provisional specification deemed to be abandoned. 1C. Have you got lucky? 1C is here, 1C is here. Not lucky. Contravention to any direction of secrecy deemed to have been abandoned. 2D. Okay. Government opines patent as generally prejudicial to public after due procedure. Yes. Revoke. 3A gets revoked. Deemed to have been revoked. No, revoked. International application not entering in national phase. Deemed to be withdrawn. It's not entering it. So withdrawn. The patentee does not desire to contest or leave his reply evidence. Deemed to have been revoked because it gets revoked finally. Answer is C. I hope it was clear. Okay, this is interesting. Question 45. The Design Act 2000 prohibits certain designs to be registered, published under various sections of the Act. In this context, match the subject matter of the appropriate section. So section 4 and section 35, 46 are interesting. 46 is for defense. Okay, so we directly have defense here. Religious symbol engraved. Public morality. 35. A design application for fiberglass model of the Taj Mahal. There is no originality here. What? Everything is straight. A chair design that is nearly identical to a classical iconic published before. 4B. A design for luxury kitchenware featuring abstract shapes that subtly resembles nude human body parts. This is also section 4D. Scandalous and obscene, right? So D, straight from the Act. Question 46. Oh, this is a different section. You have a foreign client, which is a company of small scale. Okay, so you can also have benefits. While applying the patent in India, the company wishes to take advantage of reduced fee being a small entity. Of course, you can do it as per the definition. Small entity fee benefits can only be taken by Indian SMEs. Wrong. Your client can take the advantage by filing and any other supporting document in support of their claims being small. Yes, this is what we do. The foreign company can avail fee reduction benefit if they meet the criteria as defined in SME in India. I think 2 and this is also correct. They need to file evidence of registration under. No. They don't need to register in India at all. No, this would be too much of a task. 2 and 3. Perfect. We got our answer. In the prevailing Patents Act and rules, therefore, thereunder, for which the following act, no fee is prescribed. Withdrawing an application. I think you can do it for free. Filing a statement regarding working of a patented invention on commercial scale. Yeah, 27 is free. For preparation of a certified copy of priority document and e-transmission through WIPO, this is also free. Transmittal fee for international application for e-PCT filing. Yes, this is also free. Surrendering of a patent. Opposition also happens on this. This is not fee. There is a fee associated with it. So I will go with 1, 2, 3, 4. 1, 2, 3, 4. Okay. After due examination process, a patent for efficiently cleaning polluted air and water was granted to Mr. Samyavir on 19/5/24. Mr. Samyavir comes to you for professional advice regarding payment of renewal fees. Which of the following is correct? Pay. To keep the granted patent in force, renewal fee shall be payable in expiration of the second year from the date of the patent or any succeeding year, and the same shall be remitted to the patent office before the expiration of the second or succeeding year. Yes, since the patent is of the nature wherein it solves the public health related issues by efficiently cleaning polluted, there is no need to pay. This is not there. Where the renewal fee payable in respect of 2 or more years is paid in advance through electronic mode of period of at least 4 years. 2 or more years, a period of at least 4 years, but 20%, no, 10% is there. So this is wrong here. There is only 10% reduction in the fee shall be applicable in case of advance payment of renewal fee for at least 4 years when fee is paid through physical means of bank draft. Why? We are going digital and they are talking about physical means. No, this is also wrong. Only one is correct. Okay, D is the answer. 49. Which of the following act or order of power of controller is provided in the Patents Act or Design Acts is not appealable? Okay. Can we go to High Court? Can we go to IPD? Is what they are asking. Let's see. Not appealable, huh? Controller may refuse to register a design being contrary to public order. No, this can be appealed for sure. Section 5 allows you to appeal. Section 5 allows you to appeal. Disposable of application for extension of time by the controller. For such small thing, you don't go to High Court or IPD. Controller terminates a granted compulsory license under Section 84 on application by the patentee when the circumstances. Oh, this is appealable. Section 84 is appealable. Controller may, on application by an eligible person, order for rectifying the register of design. Eligible person is what? The guy himself, the aggrieved guy, right? Rectifying this also is, you can appeal this also. Controller may give direction for prohibiting or restricting the publication of information with respect to invention when it appears to be controller that invention is relevant to defense. Oh, this is not appealable for sure. This is not appealable and time is not available. So 2 and 5. Do we have 2 and 5? Option C gives us 2 and 5. Question 50, the last question. Recently, WIPO member states adopted WIPO Treaty on Intellectual Property, Genetic Resource GR and associated TK. Which of the following is or not correct statement with regards to the same? So this happened in May 2024, where certain treaty was signed with regards to genetic resource and the associated TK. Basically, how to efficiently and transparently enable patent rights which are based on the genetic resources or the traditional knowledge. Basically, you need to provide appropriate disclosures of where did you get it from, what is the origin of it, any other information that you can provide to the patent office. And basically we are giving the credits to the genetic resource and traditional knowledge as such. So what is not correct? The treaty aims to enhance the efficacy, transparency and quality. Oh yeah, this is the objective of this treaty. Genetic resource, prevent patents from being granted erroneously for inventions that are not novel or invented with respect to genetic resource and associated TK. This is the actually objective of it. It is first WIPO treaty to include provisions specifically for indigenous people as well as local communities. This is another point of the treaty. So the treaty establishes an optional patent disclosure. Optional is the wrong word here. In fact, if you have a treaty, you are asking people to disclose where did you get this knowledge from. So this is not optional actually. You have to. So this is wrong. This is wrong. Patent office would have obligation to verify. In fact, there is a line there in the treaty which says that patent office will not have any obligations to verify the authenticity of the disclosures which have been provided. Filed prior to the entry into force of the treaty would have a grace period. No, there also there is a line which says that it's not retrofitting. Anything which is filed before May 24 does not need to worry about such disclosures around GR and associated TKs. This treaty is open for signature by any eligible party for 1 year after its adoption. Yes, this is correct. By May 23, 25. And then the will turn into force into, yeah, there is this timeline which is there. So this is correct. So we have 3, 4, 5, which is wrong, provided by 3, 4, 5. So with this, we are done going through the questions. There were too many questions to deal with. So I don't know how much value I was able to add through the discussion that we had. There could be some discrepancies between the answers that I have proposed and the answer key that is released by the patent office. But I think it's okay. You can apply your own mind, go through the sections and see what answer is accurate. So I'll see you next as and when we have another chance of creating another session. Take care then and all the best. Bye-bye.